Let us start a new topic, that is nature of punishment. The term punishment has been defined under section 53 of the Indian Penal Code. Although we can't say that it is a definition of punishment, rather it is a enumerative list which enumerates various kinds of punishment which are liable to be inflicted under the Indian Penal Code. So, as per section 53 of the Indian Penal Code, the punishment to which the offender are liable under the provisions of this code. So, what we understood by the provision of this particular section is that there are certain kinds of punishment, and if any offender is committed any offense under the Indian Penal Code, then he shall be liable for these punishments. There are certain other kinds of punishment, but which cannot be inflicted if the offender has committed any crime under the Indian Penal Code. So, what does it mean? We have many kinds of punishment, and basically these are six kinds of punishment. Number one, the death. Number two, the imprisonment for life. So, if any person committing any crime under the Indian Penal Code, then he may be punished for the death or imprisonment for life. Thirdly, has been deleted by an amendment. Fourthly, imprisonment, which is of two descriptions, namely rigorous imprisonment, that is with hard labor. So we will discuss it later, that what we call the rigorous imprisonment. Next one is simple imprisonment, and then fifthly, forfeiture of property. If the judge may inflict a punishment, if a judge wanted to inflict a punishment, then he may impose forfeiture of the property of offender. Similarly, a fine may be imposed. So generally, you will see under the Indian Penal Code that the person may be punished with or without fine. So it is the discretion of the court to impose fine or not, and while granting a punishment, while imposing a punishment under the Indian Penal Code. So before going into the detailed discussion of various kinds of punishment, we must understand that what we call the punishment. This is the general definition or the most accepted definition of the punishment. That is, punishment is the authoritative imposition of an undesirable or unpleasant outcome. So it is the authoritative imposition. Here the authoritative imposition means there is a legal system, there is legal sanction behind the punishment, there is legal authority while imposing the punishment. So court cannot inflict the punishment over the accused unless and until there is a law, that we have already studied, what we call the ex post facto law under Article 20 clause 1 of the Indian Constitution, of an undesirable or unpleasant outcome. So it is basically punishment must be undesirable or unpleasant upon group or individual. So it is imposed over the group, or over the individual in response to the particular action. So it cannot be inflicted merely over the innocent person. Rather, it is if the individual did something towards the commission of the crime, or he did something which is against the law, which is infringement of the law, and therefore in response to his action, the unpleasant action or undesirable action has been imposed by the state or under the authority of the state. Action or behavior that is deemed unacceptable. So his behavior is unacceptable by the society, and therefore the punishment is imposed by the state. Section 53 is not exhaustive. It only enumerates six kinds of punishment. There are certain other kinds of punishment which may be inflicted under the local law, which may be inflicted under the special law. So this is not an exhaustive provision, rather it is an enumerative provision which enumerates various kinds of punishment. Now come to the point, the maximum punishment and the minimum mandatory punishment. Generally, the court laid down the maximum punishment. For example, if you read out section 302, then you will find the maximum punishment, either death penalty or imprisonment for life. So it is the discretion of the court to impose the punishment. Nowadays, the maximum punishment is replaced by minimum mandatory punishment. So generally, in new legislation, you will find the minimum mandatory punishment. So generally, in case of maximum punishment, what happens? The judiciary is having discretion to impose the penalty. If suppose it is written that the offender shall be punished with 10 years of imprisonment, then it is the discretion of the judiciary, it is the discretion of the presiding officer to impose the punishment, and that punishment may either be 1 year, 2 year, 5 year, or 7 year, or even 10 years. So it is the discretion of the judiciary, it is the discretion of the presiding officer of the court to impose the maximum punishment. But in case of minimum mandatory punishment, the judiciary is having no discretion but to impose the minimum punishment. For example, under section 304B, if it is written that he shall be punished with the imprisonment which shall not be less than 7 years. So that means the court is having no discretion to award less than 7 years of imprisonment. He shall be punished with 7 years of imprisonment or more than 7 years of imprisonment. Maximum mandatory punishment is also called the tariff system of punishment. So a judge, while imposing the punishment and while exercising his discretion, the discretion should be a reasonable one. If he is exercising his discretion in unreasonable manner, then there would be injustice to the accused, injustice to the offender, the person, the wrongdoer who has committed the crime. So what we need to see is proportion should be maintained between the seriousness of the crime and the punishment imposed. What does it mean? If the crime has been committed, for let us take an example, the offense of murder has been committed and he is punished with 2 years of imprisonment. If he is punished with 1 year of imprisonment, 1 year of imprisonment, then there is no proportion is made between the seriousness of the crime and the punishment imposed. Or the person has committed the offense of theft of rupees 100 and he has been punished with 10 years of imprisonment. Again, there is no proportion between the seriousness of the crime and the punishment imposed. So there should be a balance between the crime committed and the punishment imposed. Similarly, punishment should not be disproportionately severe nor be too lenient. So it should not be disproportionately severe nor be too lenient, because if it is too lenient, then again the offenders will commit the crime again and again in the society. Or if it is more severe, then there will be imbalance, there would be chaos in the society. Come to the point, the mitigating and aggravating circumstances. If mitigating circumstances are present, then the court can reduce the quantum of punishment. If the aggravating circumstances are present, then court can enhance the quantum of punishment. Then now the question is what we call the mitigating circumstances and what we call the aggravating circumstances. For example, if someone committed an offense of theft for uh, providing food to his children. In such a situation, providing food to the children, the motive is to providing food, although he has committed an offense of theft, but the motive is something different. The motive is not bad, and therefore it is a mitigating circumstances, and while imposing the punishment, the court may reduce the quantum of punishment. Similarly, if the aggravating circumstances are present, for example, someone committed the offense of murder and thereafter he is threatening to other individual that he will commit again and again these kinds of crime, or if he just took the head of the victim, the head of the deceased, and he is roaming throughout the market with the cut with the separated head, then in such a situation it is an aggravating circumstances and therefore he shall be punished with more severe punishment. Come to the point, section 235 of the Code of Criminal Procedure, where the judgment of acquittal or conviction shall be pronounced by the judge, the presiding officer of the court. What it says? It says, after the hearing of the argument and points of law, if any, the judge shall give the judgment in the case. What does it mean? After the hearing and the arguments of both the sides, the judge shall pronounce the judgment. That judgment either may be of acquittal of the accused or the conviction of the accused. So, before pronouncing the judgment, there is an argument, there is provision to hear over the quantum of sentence. That what would be the quantum of sentence? You might have heard the case of Gurmeet Ram Rahim, Dera Sacha Sauda, where while before imposing the quantum of sentence, the judge has given him 1 day time to argue over the quantum of sentence. In case of quantum of sentence, the advocates generally argue over the mitigating circumstances and the aggravating circumstances. So on that day, the quantum of sentence is being decided. So as per section 235, subsection 2, if the accused is convicted, the judge shall, unless they proceed in accordance with the provisions of section 360, hear the accused on the question of sentence. So the judge shall, it is the mandatory duty over the judge to hear the question of sentence and then pass the sentence on him according to law. So the advocates are discussing over the mitigating and aggravating circumstances. If the mitigating circumstances are present, then the judge may impose lesser punishment as deemed under the law, or if aggravating circumstances are present, then judge may impose higher punishment. Suppose there is a government officer, he did a crime in society, and due to crime he lost his job, his salary, and the retirement benefit. So while imposing the sentence, the court may keep in mind these kinds of circumstances, and therefore these are the some mitigating circumstances, and therefore the punishment may be reduced. Similarly, if someone has already undergone to some imprisonment, then that period of imprisonment would be reduced from the quantum of sentence, because it is also a mitigating circumstance. Or if the offender is of extreme young age, for example 16 years, 17 years, and if he has committed the heinous crime, then he may not be punished with the severe punishment. For example, the Nirvaya judgment, where the prime accused, who was not convicted with death penalty, rather he was covered under the Juvenile Justice Act 2000, and therefore he was punished with 3 years of imprisonment, and rest of them who were convicted with the death penalty. So the extreme young age may be considered to be a and may be considered to be mitigating circumstances, and therefore he cannot be punished with death penalty. So the facts and circumstances, weapon used, the aggravation, the if someone induced the accused, all these things has to be taken into consideration while imposing the punishment. So what kinds of weapon were used, what kind of situation were present, and what was the mental condition of the accused at that point of time, all things has to be taken into consideration while imposing the quantum of sentence. Now come to the point, aim and objective of the punishment. The criminal law reflects those fundamental social values, expressing the way the people live and interact with each other in the society. So, whatever we are seeing in the society that are reflected by the criminal law. Criminal law reflects the fundamental social values. Similarly, it uses the stick of punishment as a means of reinforcing those values. If someone is committing any crime in the society, then there is pain of punishment, there is a stick of punishment, and therefore to enforce those social fundamental values, the stick of punishment is there, and there would be a pain of punishment to the individual who has committed the crime. Criminal law seeks to protect not only individual but the very structure and fabric of the society. If the fabric of the society is being disturbed, for example, the Hathras rape case, the fabric of the society is being disturbed by the four accused person, and therefore if any and therefore if they are trying to disturbing the public peace, if they are trying to disturbing the social fabric, then definitely there would be pain of punishment, there would be stick of punishment, and they would be punished by the court of law. Criminal law protects from the undesirable, notorious activities or behavior of the individual or organization. What does it mean? Since the criminal law is present and therefore the offender are being threatened by the pain of punishment, that they are thinking, if we would commit the crime, then definitely we would be punished by the court, and therefore it is protecting from the undesirable and notorious activities or behavior of the individual or even the organization who try to disturb the public peace. If any individual trying to disturb the public peace, tranquility, and harmony of the society, then definitely there would be a pain of punishment, and that is the aim and objective of the punishment. Come to one of the very important aspect of the criminal legislation, that is public dislike the criminal. Public in general dislike the criminal, and therefore this dislike is expressed in the form of punishment. How? You might have seen or you might have heard the 2012 December 2012 Nirbhaya rape case, or the November, sorry, September 2020, the Hathras rape case. The public expressed their dislike towards the offender, towards the rape offender, and therefore now public are demanding for their punishment. And in the year 2012 and 13, the public demanded for the punishment, and also they demanded for the change of the criminal law with respect to rape, and therefore a Criminal Law Amendment Act 2013 came into existence, and it was implemented on 3rd of February 2013. So it was the public anguish, it was the public outrage which demanded for the change in criminal law for the punishment of rape offender, and therefore it is expressed in the form of punishment. The object of punishment is to prevent the preparation of criminal act. So it is the object of the punishment to prevent the preparation of the criminal act. If any criminal is thinking that to commit any crime, so he first will think that what would be the punishment, what would be the maximum punishment. If the maximum punishment is much higher, then definitely he is not going to commit the crime in the society. Transgression of such harmful act is prevented by the threat or the sanction of punishment administered by the state. If any such harmful act is being committed, then that is being prevented or threatened by the punishment imposed by the state. Punishment is a sanction imposed by the state on the accused for the infringement of the established rules and norms of the society. So generally the punishment is being imposed by the state and not by the individual for the transgression of any rules or infringement of any established rules and norms of the society. So what does it mean? Again here there is ex post facto. Without criminal law there cannot be any punishment. So Article 20 clause 1 will always come into picture if there is punishment. Even the Manu defines the term punishment. As per Manu, punishment governs all mankind. So here the punishment is governing all mankind. Punishment alone preserves them. Punishment wakes while their guards are asleep. The wise considers the punishment, the danda, as the perfection of justice. So what does it mean? जब आप सो रहे होते हैं तब पनिशमेंट आपको गार्ड कर रहा होता है, वो नहीं सोता है, बल्कि जो अफेंडर हैं उनको पनिशमेंट का डर होता है और इसलिए वो कोई क्राइम नहीं करते हैं. Although there are various crime are being committed and the offender are not being threatened by the punishment. The protection of life, the society, the security, the liberty of individual is the essential function of the state. So these are the essential function, and how it would be protected? It would be protected by the pain of punishment imposed by the state. If the state is not imposing the punishment, then the life cannot be protected, the security cannot be protected, the liberty of the individual cannot be protected, the dignity of the individual cannot be protected. So these are the certain essential function of the state, and if there is no pain of punishment, then it cannot be protected on the part of the state. Come to one of the very important aspect of punishment, that is definition of punishment. The administration of punishment involves the intention to produce some kinds of pain. So there is an intention to produce some kind of pain, which may be partly physical and partly mental. If there is no intention to impose pain to the individual, to impose pain to the accused, then there is no meaning of imposition of punishment. So that imposition of pain, of punishment, is partly mental and partly physical. The Professor Hart defined the term punishment in the following five elements. Number one, it must involve pain or other consequences normally considered unpleasant. So if the punishment is pleasant, then definitely it has no meaning. For example, if I say to someone that your punishment is to sleep, your punishment is to roam throughout the world, so this is not a pain of punishment, and therefore it has no meaning. So punishment should be unpleasant. For example, your liberty should be curtailed, you must be put behind the bar, you cannot meet to the other people in this world, and therefore it is an unpleasant punishment. What does it mean? It must be against the nature of the human being. Point number two, it must be an offense against legal rules. So punishment must be imposed against an offense of which transgresses the legal rules. If no legal rules has been backed down, then there cannot be a punishment. Again, there is ex post facto law, Article 20, Clause 1 of the Indian Constitution. Number three, it must be for an actual or supposed offenders for his offense. So it must be imposed over the actual or supposed offender and not to the innocent people. Next, it must be intentionally administered by the human being other than the offender. So punishment is always imposed by the state, and it must not be imposed by the offender himself. So punishment must be imposed by the state. It must be imposed and administered by the authority constituted by the legal system against which the offender is committed the crime. So therefore, the punishment must be imposed by the or under the authority of law constituted by the legal system. What does it mean? There is a parliament. Parliament is passing a law to impose a punishment. Then only the presiding officer or the individual judge may impose the punishment for the act which has been committed against the society, against the legal system. Now come to another important aspect of punishment is characteristics of punishment. The first and foremost characteristics of punishment is prevention. Punishment is prevention. So what does it mean? If there is punishment, then definitely there would be prevention of crime and no other people will think of it. Number two, the punishment is coercive. It is unpleasant to the accused. It is unpleasant to the offender. The punishment is inflicted in the name of the state. If any individual is imposing the punishment, then it cannot be a punishment at all under the eye of law, and again it is a crime in the eye of law. For example, if the Khap Panchayat is imposing the punishment, then it cannot be a punishment at all, and there would be punishment, there would be a prosecution proceeding may be initiated against the Khap Panchayat. So punishment must be imposed, punishment must be inflicted in the name of the state and not in the name of the individual. Punishment is inflicted upon an offender who has committed the harm. The punishment shall not be imposed over the innocent people, rather, it should be imposed over the offender who has committed the crime, who has committed harm to the society. Regarding theories of punishment and other aspect of punishment, we will study in the next part of our lecture series. So, you must go through all these or concept, so that you must understand that what we call punishment. And in next lecture we will study about the theories of punishment. Thank you very much.